Welcome to our deep dive into the prevention of oppression and mismanagement in company. In this chapter, we'll explore the key legal protection available to shareholders, especially minorities, under the Companies Act 2013. You'll learn why these provisions exist, who can seek relief, and how the law aims to balance power within company. By the end, you'll understand the actions the National Company Law Tribunal (NCLT) can take, who can file complaints, and what. Might wonder, if company law is so detailed, why do we need special chapters on oppression and mismanagement? The answer is simple. No matter how clear the rule, there are always those who find loopholes. Law evaders can exploit these gaps, often at the expense of minority shareholders. This is why the Company Act includes specific provisions to protect against abuse of power, ensuring that the interests of all shareholders, not just the majority, are respected. Let's look at an example. Imagine Riksagan Private Limited, where 3 shareholders hold Torambe petition of the shares. In any general meeting, their votes decide the outcome, leaving the remaining shareholders with little say. This is the classic rule of majority, also known as the Fosfi Habatal rule. It means that the majority's decisions are generally respected, and courts usually avoid interfering, even if minority shareholders feel sidelined. But what happens when the majority abuses it? Fosfi Habal case set 2 key principles. First, a company is a separate legal entity from its shareholders. Second, courts won't interfere in internal management if the majority can ratify an act. However, there are exceptions. If the majority acts illegally, violates personal rights, or commits fraud against the minority, courts can step in. This chapter focuses on the last exception, fraud on the minority, where the majority uses its power to unfairly benefit itself. Fraud on the minority occurs when majority shareholders pass resolutions that discriminate against minority shareholders, giving themselves undue advantages. For example, if the majority forces the minority to sell their shares under the guise of benefiting the company, this is considered fraud on the minority. The Companies Act 2013 addresses such abuses by granting specific rights and protection to minority shareholders, ensuring their interests are not trampled by those in control. Companies Act 2013 introduced several rights for minority shareholders. These include the right to appoint a small shareholders director, the right to file applications to the NCLT in cases of oppression and mismanagement, and the right to initiate class action suits. The Act also ensures protection during mergers and amalgamation, introduces e-voting for greater participation, and in some cases, shifts approval power from the majority to the minority for relate. Let's summarize the key rights and benefits for minority shareholders. They can appoint a small shareholders director, file complaints with the NCLT, initiate class action, and have a say in mergers and amalgamation. E-voting empowers them to participate without being physically present. In related party transactions, minority shareholders often have the final say, ensuring their interests are not overlooked. Oppression, as defined by law, involves conduct that departs from fair standards and violates the trust shareholders place in a company. It must affect the person in their capacity as a member, not in any other role. For oppression to be established, there must be ongoing acts that are harsh, wrongful, and show a lack of fair dealing. Isolated incidents or personal disputes between directors and members do not qualify. For an act to be considered oppression, it must involve fraud, misfeasance, or misconduct by those managing the company. The oppression must be continuous, not just a single event, and must directly impact the member's rights as a shareholder. Disputes over salaries or failure to declare dividends, for example, are not considered oppression unless they are part of a larger pattern of unfair treatment. Mismanagement occurs when a company's affairs are conducted in a way that is prejudicial to public interest, to any member, or to the company itself. If there is a material change in management or control that could harm the company or its members, it's also considered mismanagement. The law provides remedies to address such situations, ensuring the company is run in a fair and responsible manner. Section 241 of the Companies Act 2013 allows any member or the central government to apply to the NCLT if they believe the company's affairs are being conducted oppressively or prejudicially. This includes cases where management changes could harm the company or its members. The tribunal can then investigate and provide relief if necessary. This process ensures that both individual and collective grievances can be addressed. Not everyone can file a complaint. Section 244 sets out eligibility. In companies with share capital, the lowest of 100 members, 1/10 of total members, or those holding 1/10 of issued share capital can apply. For companies without share capital, at least 1/5 of the members must apply. The tribunal can waive these requirements in special cases, ensuring genuine grievances are not blocked by technicality. Central government can also apply to the tribunal if it believes a company's affairs are being conducted in a way that harms public interest. If there is evidence of fraud, negligence, or intent to defraud creditors or members, the government can initiate proceedings. This adds an extra layer of oversight, ensuring that even powerful management teams are held accountable. Let's look at some real-world examples. If a shareholder is also a director, they can't claim compensation for salary differences through the tribunal. Failure to declare dividend is an oppression unless it's part of a larger pattern. Legal heirs of deceased shareholders can file petition even if their names aren't yet on the register. However, acting as a managing director without appointment doesn't automatically qualify as oppression. The tribunal to grant relief, the oppression or mismanagement must be ongoing. Single incidents, like renting out company property without member knowledge, don't qualify. The conduct must be part of a continuous pattern that is harsh, wrongful, and prejudicial to members' rights. This ensures that only serious, sustained abuses are addressed by the law. Section 244 details who can apply to the tribunal. In companies with share capital, the lowest of 100 members, 1/10 of total members, or those holding 1/10 of issued share capital can apply. For companies without share capital, at least 1/5 of the members must apply. The tribunal can waive these requirements, making it easier for genuine cases to be heard. When shares are held jointly, they count as one member for eligibility. Any member can apply on behalf of others with their written consent. Importantly, if some members withdraw their consent during proceedings, it doesn't affect the maintainability of the petition. The law focuses on the situation at the time the petition is filed, not on changes that happen later. To apply, members must prove their shareholding with documentary evidence, like share certificates. The law presumes that a share certificate is valid proof of ownership. Shareholding is calculated based on issued share capital, not just subscribed or paid up capital. This ensures that only those with a real stake in the company can seek relief. Section 242 gives the NCLT broad powers to resolve cases of oppression and mismanagement. If the tribunal finds that the company's affairs are being conducted oppressively or prejudicially, it can make any order it sees fit to end the problem. This could include regulating future conduct, ordering the purchase of shares, restricting share transfers, or even removing directors. Tribunal can order a wide range of remedy, regulating how the company is run, forcing the purchase of shares, reducing share capital, restricting share transfer, or terminating agreements with directors. It can also set aside transactions made to defraud creditors, recover undue gains, and appoint new directors. The goal is to restore fairness and protect the interests of all stakeholders. Tribunal can issue interim orders to regulate the company's affairs while a case is ongoing. Once the hearing concludes, it must decide whether the respondent is fit to hold office. If the tribunal orders changes to the company's memorandum or article, those changes have the same effect as if made by the company itself. Any further changes require the tribunal's approval. If a company fails to comply with the tribunal's orders, it faces significant fines. The company can be fined between 1 lakh and 25 lakh rupees, and defaulting officers can be fined between 25,000 and 1 lakh rupees. This ensures that companies take tribunal orders seriously and act promptly to implement them. When the tribunal terminates or modifies agreements with directors or managers, those individuals cannot claim damages or compensation for loss of office. They are also barred from holding similar positions in any company for 5 years without tribunal approval. This prevents those found unfit from simply moving to another company and repeating their misconduct. If someone knowingly acts as a director or manager in violation of the tribunal's order, they can be fined up to 5 lakh rupees. Other directors who knowingly allow this can also be penalized. These strict penalties reinforce the seriousness of tribunal decisions and deter future violations. Section 245 introduces class action suits, allowing groups of shareholders or depositors to file petitions if they believe the company's affairs are being managed in a way that harms their interests. This powerful tool lets groups seek remedy like restraining ultra-vires acts, claiming damages, or voiding misleading resolution. It's a major step in empowering stakeholders to hold companies accountable. And a class action, the law sets minimum thresholds. For companies with share capital, at least 100 members, PA, petition of total members, or members holding do petition of issued share capital for listed company can apply. For companies without share capital, at least 1/5 of members must apply. For depositors, at least 100 or PA, petition of total depositors, or those owed PA, petition of total deposits can file. These thresholds ensure that only significant groups. Class actions can seek a variety of remedy, restraining the company from ultra-vires acts, stopping breaches of the memorandum or article, voiding misleading resolution, and claiming damages from the company, director, auditor, or advisor. The tribunal can also grant any other remedy it deems fit, making class action a flexible and powerful tool for stakeholder protection. If a class action seeks damages from an audit firm, the liability extends to the firm and each partner involved in wrongdoing. The same applies to experts or advisors who make misleading statements or act fraudulently. This ensures that all responsible parties are held accountable, not just the company's management. In considering a class action, the tribunal looks at several factors: whether the applicants are acting in good faith, if the cause of action could be pursued individually, and the views of uninterested members. The tribunal also checks if the act in question could be authorized or ratified by the company. These checks prevent misuse of class action and ensure they serve genuine interest. If a class action is admitted, public notice is served to all affected members or depositors. Similar applications are consolidated, and a lead applicant is chosen to represent the group. The tribunal ensures that only one class action proceeds for the same cause, and the company or wrongdoers bear the cost. This streamlines the process and avoids duplication. Any order passed by the tribunal in a class action is binding on the company, its members, depositors, auditors, and advisors. This ensures that the outcome of the case applies to everyone involved, providing certainty and closure to the dispute. If a company fails to comply with a tribunal order in a class action, it faces fines from 5 lakh to 25 lakh rupees. Defaulting officers can be imprisoned for up to 3 years and fined up to 1 lakh rupees. These strict penalties reinforce the seriousness of class action outcome. The tribunal finds that a class action application is frivolous or vexatious. It can reject the application and order the applicant to pay costs up to 1 lakh rupees to the opposite party. This discourages misuse of the class action process and ensures only serious cases are pursued. Section 245 does not apply to banking company. This exemption recognizes the unique regulatory environment of banks, which are already subject to strict oversight by financial regulators. Other companies, however, must comply fully with class action provision. Applications under Section 245 can be filed by any person, group, or association representing affected individuals. This broadens access to justice, allowing collective action by those impacted by a company's conduct, even if they are not direct shareholders or depositors. Sections 337 to 341 of the Companies Act, dealing with winding up, also apply to applications under Section 241 and 245. These sections cover penalties for fraud, improper accounts, and fraudulent conduct. This ensures that those who abuse company law face serious consequences, even if the company is not being wound up. If a company's board decides not to recommend a dividend due to low profits, this is not considered oppression or mismanagement if it's in the company's best interest. The tribunal recognizes that business decisions, even unpopular ones, are not grounds for legal action unless they form part of a larger pattern of abuse. If a company alters its articles of association to empower the board to transfer shares of competing shareholders and does so following due process, this is generally not considered oppression. The law protects the company's right to manage its affairs, provided changes are made lawfully and in the company's interest. A company with 150 shareholders and 1,000,000 shares, at least 100 members or those holding 1/10 of issued share capital can apply to the tribunal. This ensures that only those with a significant stake can initiate legal action, preventing frivolous or malicious complaint. If a shareholder passes away, their legal heir can file an application with the tribunal, even if their name isn't yet on the register. This ensures continuity of rights and protects the interests of those who inherit shares. If someone acts as a managing director without formal appointment, this alone does not constitute oppression. The tribunal focuses on whether the conduct is part of a broader pattern of unfair treatment or abuse of power. Shareholders have the right to inspect company documents to support their petition. However, denial of inspection alone does not amount to oppression. The tribunal will not direct directors to provide inspection solely to help a petitioner gather evidence for a case. Directors must issue shares in the company's best interest, not for personal gain. If shares are issued solely to convert a majority into a minority, the tribunal can intervene and prevent such oppression. Directors hold a fiduciary position and must act for the benefit of the company as a whole. Companies Act 2013 provides robust mechanism to prevent oppression and mismanagement. From individual application to class action and from tribunal powers to penalty, the law ensures that all stakeholders, especially minority, are protected. Understanding these provisions empowers shareholders to safeguard their rights and promotes fair corporate governance. In conclusion, the prevention of oppression and mismanagement is central to maintaining trust and fairness in corporate India. The law balances the power of the majority with the rights of the minority, providing clear avenues for redress and strong penalties for abuse. Whether you're a shareholder, director, or advisor, understanding these rules is essential for responsible participation in any company. Stay informed, stay protected.